A very good morning to you all protocols observed, and welcome to the final of the 32nd edition of the Christof Heyns African Human Rights Moot Court Competition. I'm just going to introduce the judges so that we know who they are, and then I'm going to hand over to the president of the court to take us through and be in charge of the proceedings for the next 2.5 hours. On my immediate left, we have Advocate Claudio Fokiko. He is from Mozambique. He is a lawyer. He's running a law firm in Mozambique. He is also the vice president of the National Human Rights Commission in Mozambique through the Bar Association of Mozambique. Next to him is Judge Dr. Sylvain Ore. He is a lawyer. He also teaches international human rights law, and is also the former president of the African Court on Human and People's Rights. His tenure ended in 2021, and he is from Ivory Coast, Cote d'Ivoire. I'm going to skip the presiding judge, whom I'll introduce last. Next to him is Dr. Wilson Almeida Adau. He is from Angola. He is also a lawyer, but he also teaches international human rights law at the Catholic University, and he is also the director of the Center for Human Rights at the same university in Angola. Next to him is Professor Laurence Begog Larsen. Forgive my French. She's a professor of law at the Sorbonne Law School in Paris, France, and she was also a judge of the Constitutional Court of Andorra, and she was the court's president from 2014 to 2016. She also enjoys teaching international human rights law. Mainly, she told me that she loves comparing the African human rights system, the inter-American system, and the European court's regional system of human rights. So she combines all the regions, and it will be interesting to see how she's going to interact with the advocates before us this morning. And then finally, we have Justice Dr. Ernest Owusu-Dapa. He's a lawyer. He is also taught international human rights law. He has a law practice here in Kumasi. He is the former dean of the Faculty of Law of KNUST. And currently, he is a judge of the Court of Appeal here in Ghana, based in Accra. He has been involved in the Moot for a very long time, so he understands a lot of what happens in the Moots and how the proceedings happen, particularly the preliminary rounds as well as the final. So this is your bench this morning, very eminent judges who understand international human rights law, who practice it, who have taught it, and who have presided. Some of them, I think 3 of them have presided in the courts. I also just want to mention that in terms of experience at the regional level, because I think the hypothetical case includes an aspect on children's rights, that Dr. Adau, Wilson Adau, is also a member of the African Committee of Experts on the Rights and Welfare of Children. So we are going to be interacting with somebody who is very at the center of protection of children's rights at the African regional level. So this is the eminent panel of judges that are presiding today. I wish you all the best. I will now hand over to the presiding judge, Justice Dr. Ernest Owusu Dapa. I just wanted to also to ask either Marty or Syed, if they're in here, to hand over a copy of the hypothetical case to the presiding judge. I think it's not on before him. If we can hand it over to him now as I hand over to him. Thank you so much, presiding judge. Over to you.
Thank you very much, Deputy Director Lloyd, for Center for Human Rights, University of Pretoria, the main organization behind this. Good morning to all of you. Just get through Raba, Isaba, Saki, Tokonu, the Honorable Chief Justice, who was originally supposed to have presided over this final competition, but due to prior commitments overseas, she is not here, and I have been appointed to hold brief for her in this final competition. So at the end of the competition, we extend some few words she would like you to hear as future lawyers and law students when we are giving our comments. So I will call the bailiff to call the case before the court. Can we get the translators?
All rise. The African Court on Human and People's Rights is now in session in the matter between Gozanga Human Rights Association and the State of Saint-Ifia. The Honorable Judge, Justice Dr. Ernest Owusu Dapa, presiding.
La Cour africaine des droits de l'homme et des peuples est en session dans l'affaire entre Association des droits de l'homme de Gozanga et État de Saint-Ifia. L'honorable juge Owusu Dapa préside.
Right, so before we start, we'd like to get the time allocation by both parties. So if you put it down, you can share with us, or we take it that they're speaking for 10 minutes each. So applicants, what reservation have you made for rebuttal so that we take note of that before we continue? So the rules we understand are that each side will be given 1 hour to present your case. So as applicant, you will have to tell us what portion of the 1 hour you reserve for rebuttal. Shall we have representation for the applicant?
President Judge, Your Excellencies, good morning. My name is Njapit Ntikia, first agent for the applicant, the Gozanga Human Rights Association. Appearing alongside me,
Mame Ama Anand, second agent for the applicant.
Ajubi Kete Bando, third agent for the applicant.
Trevor Kamau, counsel for the applicant.
Your Excellencies, today this honorable court, much obliged, Your Excellency, we reserve 3 minutes for rebuttals. Yes. 12 minutes. Much obliged, President Judge. Today this honorable court is faced with a question of a republic that has and continues to condone acts of illegal mining, corruption, which has resulted in the diminishing of public resources, depletion of the environment, the exhaustion of public funds which would have been used to curb a public pandemic, and inadequacy of funds to sustain education policies. I will take 12 minutes of this court's time to demonstrate that this honorable court has jurisdiction to entertain the matters before it. The structure of my argument is as follows. First, I will demonstrate before you, Your Excellencies, that this court has material jurisdiction. Second, I will demonstrate before you that this honorable court has territorial jurisdiction. I will also endeavor to demonstrate before you that this honorable court has personal jurisdiction. Lastly, Your Excellencies, I will demonstrate to you that this honorable court has personal jurisdiction to entertain the matter before it. Every application that comes before this honorable court, the court has a mandatory obligation to conduct a preliminary examination of its jurisdiction, whether contested or not. This was the holding of this honorable court in Wanjara versus the State Republic of Tanzania in 2020 Africa Law Report. In Miriam Kwame versus Temali, this honorable court held that it must satisfy itself that it has material jurisdiction, temporal jurisdiction, personal jurisdiction, and territorial jurisdiction. On material jurisdiction, the rule is found in Article 3, Sub-Article 1 of the court's protocol establishing this honorable court, which provides that this honorable court has the jurisdiction to entertain matters that relate to the interpretation and the application of the African Charter, the court's protocol, and any other relevant human rights instruments.
Agent, we've had the benefit of the memorial by the respondent. I've heard mentions of jurisdiction. Is there any aspect of jurisdiction which is contested by the respondent?
Much obliged, Your Excellencies. In the case that the respondent do not contest material jurisdiction, it is still the obligation of this honorable court to conduct the preliminary examination of its jurisdiction. On material jurisdiction, Your Excellency, reverting to my arguments, this court has the duty to conduct a preliminary examination which seeks to determine whether the matters relate to the application, the interpretation of the African Charter on Human and People's Rights, the court protocol, and any other relevant human rights instrument. In the instant case, the Ngozanga Human Rights Association brings before you issues of human rights violation, which are catered for by the various relevant human rights instruments ratified by the state of St. Lucia. On territorial jurisdiction, the rule is that this honorable court must determine whether the matters which are brought before it happened before the deposition of the optional declaration under Article 34, Sub-Article 6 of the court's protocol. Your Excellencies, a keen interrogation of the facts will bring to the fore the fact that the matter relating to the Gohara members and the children, the FSH policy, and the Center for Sexual Minority Rights occurred after the ratification or the deposition of the optional declaration in 2017, Your Excellencies. It is therefore not in contention. Admittedly,
But
however,
agent, we are told that the Supreme Court of the respondent state has ruled that it is a dualist country. So having merely signed and made the position, if it has not been domesticated into the municipal law of the respondent state, will this court still have jurisdiction?
much obliged, Your Excellency, for a very valid question. Article 3, sub-article 1, provides that this honorable court has to determine whether it has jurisdiction based on the African Charter and the court's protocol. However, Your Excellency, in Ernest Mtungwi versus Tanzania, this honorable court held that it has to determine whether the decision by the domestic courts have met the international master or the international standards. It is also our submission to you that according to the Vienna Convention on the Law of Treaties, courts, domestic courts and states cannot rely on domestic decision or laws to override the application of international law. Your Excellencies, on personal jurisdiction, it is our submission that the rule is that the state must have deposited the optional declaration and the NGO must have observer status before the African Commission. It is our submission to you that the Gozanga Human Rights Association has gained observer status in 2015. The state of St. Sphere has made the optional declaration in 2017. It is therefore our submission to you that this honorable court has personal jurisdiction to entertain the matters before it. On territorial jurisdiction, the rule is that all matters that occur within the territory of the state, this honorable court has jurisdiction to entertain. In the decision of Isa Konate versus Burkina Faso, in the year 2014, African law reports, this honorable court held that it had territorial jurisdiction for the matters or the issues brought therein involved matters that occurred within the territory of Burkina Faso. Your Excellency.
And one of the matters before the courts, the trial took place in the Republic of Camelot, and the Camelot government granted pardon. And Camelot is not a party in this matter. Can this court still proceed and entertain that particular issue relating to the trial and the pardon?
Much obliged, Your Excellency. The actual offense of illegal mining occurred in the state of St. Sphere. That therefore does not exclude this honorable court from determining the violation of human rights for the matters or the issues occurred within the territory of the State Republic of St. Sphere in the eastern region of Akan. Lastly, Your Excellency, it is on temporal jurisdiction. The rule is that this honorable court has to determine whether matters occurred after or before the deposition of the optional declaration under Article 34, Sub-Article 6 of the Courts Protocol. Your Excellencies, it is our submission to you that the matters that involve the FSH policy, as is borne out of the fact, matters involving the violation of the right of the Gohara staff members and the children, the matters involving the Center for Minority Rights, occurred after the ratification of the optional declaration. Admittedly, however, the issue on corruption of Mr. Nzana Adongo and the effects of the illegal mining occurred in 2018 before the ratification of the Courts Protocol in 2019. We, however, submit to you that this Honorable Court in Kijiji Isiaga versus Tanzania held that it has jurisdiction to entertain continuous matters. Continuous matters, Your Excellencies, are matters that continue to subsist after the ratification of the optional declaration. As is borne out of the facts, it is evident that the effects of the illegal mining, the corruption of Mr. Nzana Adongo, are still felt up to date in the state of St. Sphere. Your Excellencies, having come to the conclusion of my arguments, it is our prayer before this Honorable Court that it finds it has jurisdiction to entertain all the four issues brought before you. If I am of no more help to this Honorable Court, I now yield the stage to the second counsel of the applicants to further our submissions.
Admissibility.
Much obliged, Your Excellency. Indeed, the second counsel, learned counsel Ama, will address admissibility.
Yes.
Advocate for the applicant. You said that corruption is not a continuous matter. Are you talking about continuous matter or continuous violation?
Much obliged, Your Excellency. Our submission before this Honorable Court is that the effects of corruption perpetrated by Mr. Nzana Adongo continue to have a violation effect to the citizens of the State Republic of St. Sphere. Much obliged, Your Excellency, hoping that I have satisfied that question, and I will yield the stage to the second counsel of the applicants to further our submission. Much obliged, Your Excellency, for that very important question. Continuous violation are violations that before the ratification, its effect or subsistence are continuous in nature. In other words, Your Excellency, simply put, that the effects of the violation might have occurred before, but its effects are continuous or subsistent in the state.
Right. Point noted. So yield to your colleague.
Much obliged, President Judge.
Mr. President, Your Excellencies, may it please the court, Kwame Ama Anan, appearing as second counsel for the applicant, Gozaga Human Rights Association. Within the next 15 minutes, I will be addressing this court on the preliminary issue of admissibility, as well as a fair substantive issue regarding Sentipia's failure to hold Mr. Putinyango accountable for illegal mining and Mr. Nzana Adongo accountable for corruption. With Your Excellency's permission, I would begin. On the preliminary issue of admissibility, the applicant submits that the instant application is admissible. Your Excellencies, Article 6.2 of the Courts Protocol mandates this court to rule on the admissibility of cases having due regard to Article 56 of the African Charter. Your Excellencies, Article 56 makes provision for 7 admissibility conditions. However, in this present matter, the requirement to exhaust local remedies under Article 56(5) of the African Charter appears to be in contention. On this, the applicant presents 2 submissions. First, that local remedies have been exhausted in the cases of the illegal mining and the CSMR. And second, that the requirement to exhaust local remedies should be waived in the cases concerning dishonest corruption, the treatment of the children and very senior members, as well as the FSH's policy. On our first submission regarding the exhaustion of local remedies in the cases of the illegal mining and the CSMR, Your Excellencies, the applicant submits that these cases are admissible because from paragraphs 14 and 26 of the facts, these matters were pursued up to the Supreme Court in Sentifia, which is the final appellate court, as seen from paragraph 6 of the facts. On our second submission, regarding the waiver of the requirement to exhaust local remedies in the cases concerning dishonest corruption, the treatment of the children and very senior members, as well as the FSH's policy. Your Excellencies, on this, the applicant submits or that argues that the requirement should be waived because local remedies are unavailable, ineffective, and unduly prolonged. Yes, Your Excellencies. Your Excellencies, in accordance with Article 56(5) of the African Charter and also the African Commission decision in Jawara versus the Gambia, decided in 2000, the requirement to exhaust local remedies would be inapplicable where the remedies in the respondent states are unavailable, ineffective, insufficient, and where they are unduly prolonged. Your Excellencies, in the matter concerning Mr. Insana's corruption, the applicant argues that local remedies are unavailable. Your Excellencies, a remedy is available if it exists and can be pursued without impediment. This was noted by this court in Norbert Zongo and others versus Burkina Faso, 2014, One African Court Law Report, page 219 at paragraph 109. Your Excellencies, a recourse to section 5 of the OSP Act in Annex 1 of the fact reveals that the OSP is a body mandated to investigate and prosecute corruption allegations. Your Excellencies, this is a discretion vested in the OSP. In effect, private persons such as the applicant cannot have a course of action in matters of corruption. Your Excellencies, it is on this basis that we submit that local remedies are unavailable to the applicant and humbly implore this court to waive the requirement to exhaust them. Concerning the FSH's policy, Your Excellencies, on this matter, the applicant also argues that local remedies are unavailable. If I may direct this court to paragraph 6 of the facts, it reveals that only citizens can challenge the decision of a public body. Your Excellencies, in this present matter, the applicant is a juridical person and not a citizen, as seen from paragraph 8 of the facts. As such, it does not have the capacity to challenge the limitation of the FSH's policy.
Agents, is it your argument that juridical persons cannot have nationality of the respondent state?
Your Excellencies, our argument before this court is that under Sentifian law, the concept of nationality is conferred to natural persons as well as juridical persons such as the applicant. However, in order to challenge the limitation of the FSH's policy, the applicant must be a citizen. And in this present matter, considering that the applicant is an artificial person it does not have the capacity to institute any action within the respondent state. Your Excellencies, from paragraph 6 of the fact, it reveals that all citizens can challenge the constitutionality of a legislation or an action of a public body. And given that the decision was taken by the government to limit the FSHS policy to only 150 less endowed schools, which has resulted in a violation, the applicant cannot have a remedy within the respondent state, but only has a recourse of action before this honorable court. And that is why we are before this court, urging the court to admit the matter and determine the merits of the case. Your Excellencies, proceeding to the argument on the treatment of the children and GORES senior members. The applicant argues that local remedies are ineffective. Your Excellencies, a remedy is effective if it offers a prospect of success. And this was noted by the African Commission in Jawara versus the Gambia, 2000, African Human Rights Law Report, page 107 at paragraph 32. If I may direct this court...
May I? Can you appoint some case of African court regarding these issues?
Your Excellency.
Can you appoint one case of African court regarding the issue of local remedy rules?
Yes, Your Excellencies.
Thank
Your
you.
Excellencies, in the case of African Commission versus Kenya, decided in 2017, the court noted that where the local remedies are unavailable or do not meet the criteria of availability, effectiveness, and sufficiency, then the requirement to exhaust remedies would be waived.
The commission and decision of the court on the matter, which of these two decisions should this court be persuaded by?
Your Excellencies, this court should be persuaded by its own decisions. Though its decisions are not binding by it, we urge this court to draw inspiration from its own decisions. Reverting to my submissions, Your Excellencies, if I may direct you to paragraphs 14 and 26 of the facts, Your Excellencies, we would notice the state's alacrity in determining the appeals pertaining to the illegal mining and the CSMR. But sadly, comparing those cases to the present matter, the respondent state has adopted an adverse posture in determining GORES appeal. Your Excellencies, from July 2021 up until May 2023, 23 months have elapsed, and yet no date has been set for hearing GORES appeal. Your Excellencies, we do acknowledge that the 2 years has not been exhausted. However, it is our submission that this unwarranted delay to set a hearing date is discriminatory. Your Excellencies, on one hand, the Court of Appeal has gone ahead to expeditiously determine other matters, such as the illegal mining and the CSMR, as can be seen from paragraphs 14 and 26 of the facts. However, concerning GORES appeal, the Court of Appeal has not even set a hearing date, and it has been 23 months. And it is for this reason that we submit before this court that the delay is indicative of undue prolongation and has consequently curtailed the applicant's right to remedy. Your Excellencies, on this basis,
Just as we render decision, the Court of Appeal sets a hearing date and it also comes out to the judgment. And where there is this discrepancy between the judgment of the Municipal Court of Appeal and the African Court, how will the respondent state be guided?
Your Excellencies, I do understand your concern. However, it is our argument before this court that the respondent state has adopted an adverse posture in determining GORES appeal. And as such, the likelihood of the courts pronouncing on the matter is very low. It is for this reason that we humbly implore this court to admit the matter for determination. Your Excellencies, the applicant is in a state of limbo. On one hand, lies a judiciary given enough signs that it cannot grant the applicant the remedy they deserve. On the other hand, is a jurisdictional impasse given the same applicant a denial of access to the very courts they are supposed to tend to. Your Excellencies, it is on these grounds that we urge this court to waive the requirement to exhaust local remedies in the cases concerning dishonest corruption, the treatment of the children and very senior members, as well as the FSH's policy, and determine the matter based on its merits. Proceeding to our first substantive issue regarding Sentifia's failure to hold Mr. Puti Yengo accountable for illegal mining and Mr. Insana Adego accountable for corruption. Your Excellencies, on this, the African submits that the respondent state has violated the African Charter and other human rights norms because, first, the state failed to hold Mr. Puti Yengo accountable for the illegal mining and consequently violated the victim's right to reparations. Second, Your Excellencies, the state failed to take any remedial measures to rehabilitate the decimated environment and have therefore breached their obligations to protect the environment. Your Excellencies, on our first submission regarding the state's failure to hold Mr. Putin accountable. Your Excellencies, a state in whose territory a violation occurs bears the sole duty to prosecute. This was noted by the African Commission in Zimbabwean NGO Forum versus Zimbabwe, 2006, African Human Rights Law Report, page 128 at paragraph 146. Your Excellencies, this duty of the state to prosecute cannot be delegated unless warranted by necessity. For this position, we refer the court to the International Law Commission 2014 report on the duty to prosecute or extradite. Your Excellencies,
just as we witnessed in the instant case with Camelot, and prosecution takes place in the other state with which respondency has extradition, would that not suffice to discharge the obligation of the respondent state to prosecute?
Your Excellencies, we do understand your concern. It is, however, our submission that the extradition arrangements, as seen from paragraph 13 of the facts, in the first place, was unnecessary and constituted an unjustified entrustment of the state's duty to hold Mr. Putin accountable. Your Excellencies, as a result of this unjustified entrustment of the state's duty, a brazen impunity has occurred since Camelot granted Mr. Putin pardon shortly after he began serving his sentence. Your Excellencies.
So your concern is the pardon which Mr. Putin was given, having been convicted?
Your Excellencies, the pardon and also the state's failure to compensate the victims of the illegal mining. Your Excellencies, we do acknowledge that Camelot prosecuted Mr. Putin and sentenced him. However, it is our submission that such criminal accountability is not sufficient because the respondent state has failed to compensate the victims of the illegal mining. Your Excellency.
Yes. Take a question from my colleague.
What is the legal standard of compensation in international law that they are using?
Your Excellencies, the legal standard for compensation is that a victim who has suffered harm must be compensated in the sense that he must be given reparations in order to deal with the harm that has occurred. Your Excellencies, for this, we rely on the ILC articles on state responsibility from Article 34, Your Excellencies. Your Excellencies, in the present matter, the respondent state, through its High Court, awarded $3.5 million monetary compensation to the victims of the illegal mining. Not only this, the state, also through Camelot, obtain a pledge to compensate the victims of the illegal mining. But sadly, none of these compensations have until this very day been paid to the victims of the illegal mining. Your Excellencies, we do acknowledge.
Take a question.
Vous comprenez, vous avez besoin des oreillettes. Ok. Vous, maître, vous parlez d'une compensation financière. Mais est-ce que la compensation financière est la plus idoine, la plus pertinente dans ce cas de figure? N'existerait-il pas d'autres compensations financières que le droit international pourrait imposer à l'État? Et si oui, lesquelles?
Most grateful for your question, Your Excellencies. Your Excellencies, our concern is in relation to the financial compensation because, as seen from paragraph 14 of the fact, the livelihood of these victims have been greatly affected, therefore leaving them extremely vulnerable and destitute. Your Excellencies, we are also before this court seeking that the court orders the respondent state to not take further steps to avoid, or rather, seeking for the court to make an order as to a non-repetition of the state's action in respect of the illegal mining.
All right, your time is up. Thank you.
Very well, Your Excellency. Your Excellencies, I respectfully yield the floor to the third counsel to address this court on the second and third issue. Respectfully, sir.
Yes. Proceed.
Mr. President, Your Excellencies, may it please the court, Ajubi Kete Bando, third agent for the applicant, Gozanga Human Rights Association. In the next 15 minutes, I would be addressing this court on substantive issues 2 and 3 concerning the treatment of the children and the 20 Gora senior members at the villa, the limitation of the FSHS policy. With Your Excellency's permission, I would begin. Your Excellencies, on substantive issue 2 concerning the treatment of the children and the 20 Gora senior members at the villa, the applicant advances 2 heads of argument. First, that the treatment of the children at the villa undermine their best interests, and second, that the detention of the 20 Gora senior members was arbitrary. On the first head argument, Your Excellencies, because of the vulnerability of children, Article 4 of the African Charter on the Rights and Welfare of the Child obligates states to ensure that in all measures taken, the best interest of the child is prioritized. This duty, according to the African Committee of Experts on the Rights and Welfare of the Child in Center for Human Rights versus Senegal, decided on 15 April 2014 as paragraph 34, imposes a primary obligation on states to take measures that would contribute effectively to the physical, psychological, and emotional well-being of the child.
Agents in determine whether the state has lived up to the obligation to uphold the best interest of the child in decision-making or deployment of measures. Is it an objective exercise or subjective exercise?
Your Excellencies, it is a subjective exercise as it is based on the discretion of the state. However, the state must ensure that the best interest of the child remains of primary consideration. However, Your Excellencies, in the present matter, 50 street children were detained at the villa, evidently from paragraph 19 of the facts. Your Excellencies, the villa is a prison surrounded by high walls and was heavily guarded. Your Excellencies, according to the 2015 United Nations report by the Special Rapporteur John Mendes on torture, detaining children under such conditions exposes them to emotional distress, fear, trauma, and even disturbs their mental health and character orientation. It is on these grounds that we submit.
Vous venez de mentionner des principes présentés par le haut rapporteur aux Nations Unies, mais est-ce que ces principes sont contraignants pour notre cours? Est-ce que vous ne pourriez pas plutôt nous présenter une jurisprudence qui serait contraignante pour notre cours, qui mettrait en évidence le fait que les enfants doivent être préservés?
Your Excellencies, admittedly, the report by the UN Special Rapporteur is only of persuasive effect by this court. However, in accordance with Article 60 of the African Charter, which allows this court to draw inspiration from instruments adopted by specialized agencies of the United Nations, we humbly implore this court to equally draw inspiration from the UN Special Rapporteur report.
But that is applicable where there is no jurisprudence from the African Court or the Commission. And we need to start the burden of letting this court know whether there is no relevant jurisprudence.
Your Excellencies, the African Court has only had the opportunity to determine matters concerning children in the case of APDF versus Mali, 2016, One African Court Law Report, page 316. And unfortunately, the discussion of conditions such as what the children has been put in was not discussed by the African Court. And that is why Agent is imploring this court to draw inspiration by the instrument of the UN in the circumstances. Your Excellencies, it is therefore our submission that instead of the respondent states detaining these children at the villa, they should have accommodated them in a much more suitable institution of care, such as a foster home, as they are obligated to under Article 25(2)(a) of the African Charter on the Rights and Welfare of the Child. To make matters worse, Your Excellencies, the respondent states returned these children to the streets where they found them, after they had forcibly vaccinated them, evidently from paragraph 22 of the facts, in contravention with their very obligation to reunite these children with their families, under Article 25(2)(b) of the African Charter on the Rights and Welfare of the Child. It is on these grounds that we submit that Sentefia undermined the best interests of the child in its treatment of the children at the villa. On the second head argument, it is our submission that the detention of the 20 GORA senior members was arbitrary.
So, Agent, were this called to make a positive or favorable finding that the respondent state actually breached its duty to protect the best interests of the child in the circumstances that we have canvassed, what remedy would be appropriate in the circumstances?
Your Excellencies, the appropriate remedy will be for the children to be compensated for the psychological harm that they have suffered, and for the respondent state to reunite, trace the relatives of these children, and reunite them with their families.
Is there any guide regarding the quantum of compensation which this court can decree as a remedial measure?
Admittedly, Your Excellencies, there isn't a guide. However, we are imploring this court to assess the injury that has been committed against these children to determine what will be financially accessible to remedy the violation. Your Excellencies, on the second head argument.
As before your second argument, the applicant defends that children can deny the vaccination. In COVID time, your argument is children can deny being vaccinated by the state's authorities?
Agent cannot understand.
Now, the vaccination, which was compulsorily done, could it have been avoided by the respondent state, having regard to the public health crisis, which was prevalent in the respondent state?
Excellencies, the applicant acknowledges that the respondent state was indeed experiencing the outbreak of the COVID-19 virus. However, compulsory vaccination does not mean forcible vaccination. However, what we find in the present matter is that the respondent states evidently from paragraph 22 of the facts vaccinated these children without any form of explanation or testing, and as to the positive and negative side effects of this vaccine, despite their protestations.
And this brings to the fore the question my colleague judge is asking, that when it comes to vaccination, especially in the face of public health emergency, must the patient or the person be vaccinated consent before the state can do that?
Yes, Your Excellencies. Your Excellencies, the only circumstance where the state can override the consent of these children is if these children indeed had the COVID-19 virus, which would affect the public health. But the respondent state did not even test these children to ascertain whether they have the COVID-19 virus. And therefore, they should have at least, at best, Your Excellencies, obtained their consent before measuring out the vaccination on them. It is on these grounds that we submit that Sintefia.
Sorry, and thank you for your presentation. I have a question for you. On what grounds did you ascertain that the state did not test in terms of evidence for COVID? You want to find some kind of evidence for you to bring before this court.
Much obliged, Your Excellencies. If I may direct this court to paragraph 22 of the facts, it expressly states that the respondent states, despite the protestations, vaccinated these children without any form of testing or explanation as to the positive and negative side effects of the COVID-19 vaccine. It is on these grounds that we submit that Sintefia has violated their rights.
By agent, you have assisted the court if you had alluded to World Health Organization guidelines on COVID-19 vaccination, as to whether prior testing is mandatory before vaccination.
Your Excellencies, admittedly, prior testing is not mandatory before prior testing. However, at the same time, prior consent by the patient or by the person receiving the vaccine is necessary, Your Excellencies, because the right to health of every person entails the person's right of autonomy over his own body, including his right of refusal, according to the Nairobi guidelines on the socio-economic rights in Africa, specifically as paragraph 64 and 65. And so based on this, we still argue that the respondent state should have at least, in accordance with international law best practices, obtained the consent of these children before vaccinating them in the circumstance. On the second head argument, it is our submission that the detention of the 20 GORA senior members was arbitrary. Your Excellencies, any arrest and detention is arbitrary if it is not justified by law or followed by due process. And this is according to your decision in Onyanchi and Njoka versus Tanzania, 2017 2 African Court Law Reports, page 65, specifically as paragraph 132. The applicant therefore argues that the detention of the 20 GORA senior members was arbitrary because Sintefia failed to follow due process. Your Excellencies, under Article 71D of the African Charter, any person who has been arrested and detained has the right to have his cause heard within reasonable time and before an impartial tribunal. Your Excellencies, this right cannot be derogated from under any circumstance whatsoever.
Can you give any assistance to this court regarding what will amount to reasonable time in terms of bringing arrested person to trial?
Your Excellencies, admittedly, reasonable time is undefined. However, the African Commission in Majuru versus Zimbabwe defined reasonable time to be 6 months, subject to the peculiar circumstances of every case. However, Your Excellencies, what we find in this matter is that throughout their 7-month detention, the respondent states never arraigned these 20 GOA senior members before any court for trial and only released them after they had been coerced to take the COVID-19 vaccine. It is on these grounds that we submit that Sentefia violated the African Charter and other international human rights norms in its treatment of the children and the 20 GOA senior members at the villa.
Now, will you still go by that argument where their detention was not detention for having committed a crime, but being quarantined in terms of being at risk for some public health emergency?
Your Excellencies, it is our submission that that would not hold in the circumstance because there is no evidence that these 20 GOA senior members had the COVID-19 virus, and so there was no need to quarantine them in the first place. And so the state still had the obligation to arraign them before a court for trial since they had arrested them for flouting their directive. I shall now proceed to address the court on substantive issue 3 concerning the limitation of the FSHS policy to 150 less endowed schools. On this, it is our submission that the limitation is discriminatory in nature and has consequently violated the rights to education. Your Excellencies, equality of persons and the principle of non-discrimination under Article 2 of the African Charter are fundamental. As such, any limitation based on social origin which hinders the equality of treatment in the access to education is discriminatory pursuant to Article 1 of the UNESCO Convention against Discrimination in Education. The applicant therefore submits that the limitation of the FSHS policy to only 150 less endowed schools to the exclusion of the schools in the major cities discriminates against the poor urban students who are similarly placed with those in the rural areas. Your Excellencies, we do acknowledge that the right to education is a socio-economic right which states have a duty to progressively realize. And we also acknowledge that the state had been affected by the COVID-19 virus. However, we still submit that the limitation was not necessary because there were viable alternatives that the responding state could have resorted to ensure the full implementation of the FSHS policy. First, Your Excellencies, the state could have simply capitalized on its precious Hugono tree, which evidently from paragraph 2 of the facts.
Agent, because of time, let's test this argument a little bit before your time is up. Is it not enough sign of good faith by the state having practiced universal free SHS and later on finding that resources are not adequate and wanted to scale down the scope of implementation? Is that not enough?
No, Your Excellencies. Inasmuch as we acknowledge this novel approach by the respondent states, the state cannot abruptly retrogress in its policies that it implements in its states. Your Excellencies, for this, we rely on General Comment number 13 on the right to education by the UN Human Rights Committees, which provides that a state cannot retrogress in its measures and would only be able to do so where it has proven that it has resorted to all viable alternatives in the respondent state. And here, Your Excellencies, it is our argument that the respondent state did not resort to all the viable alternatives before retrogressing in this FSHS policy.
Give us one important viable alternative which the respondent state will have availed itself of.
Much obliged, Your Excellencies. Your Excellencies, the respondent state could have capitalized on its precious Hugono tree, which evidently from paragraph 2 of the facts is primarily used for the production of immune boosters and drugs for respiratory-related diseases. Your Excellencies, considering that the COVID-19 is a respiratory disease, according to the World Health Organization, it was the perfect opportunity for Sentefia to generate revenue and attract foreign investment by capitalizing on this
Very well,
Hugonochi.
your time is up, so you have to yield.
Much obliged, Your Excellencies. If I may be of no further assistance to this court, I respectfully yield the floor to my co-agents to address the court on substantive issue 4. Respectfully submitted.
President Judge, honorable members of the bench, good morning. My name is Trevor Kamau, fourth counsel for the applicant. I shall be addressing this court in the remaining 15 minutes in regards to merit D. If this court seeks no further clarification, I wish to proceed. Much obliged to Excellencies. Morality, culture, religion, and the opinion of the majority cannot indeed be used as a justification for limiting the rights of the minority in a society. Your Excellencies, this is our position, especially in instances where the majority are monstrous towards the minority. In regards to merit D, Your Excellencies, it is our submission that the refusal to register Center for Sexual Minority Rights was indeed a violation of the provisions of the African Charter. We submit this in 3 limbs of argument. Firstly, that the refusal to register Center for Sexual Minority Rights was discriminatory. Secondly, that the refusal to register Center for Sexual Minority Rights did not meet the limitation test as was set by this court in the case of Issa Konate vs. Burkina Faso and Victoria Ingabire vs. the Republic of Rwanda. Lastly, Your Excellencies, we shall submit that the refusal by the respondent state to register Center for Sexual Minority Rights was indeed a violation of the right to freedom of association. In regards to our first limb of argument, we submit that the actions of the respondent state was discriminatory. We cite the provisions of Article 2 and Article 3 of the African Charter, which collectively provides for the right not to be discriminated against. Your Excellencies, this was indeed confirmed by you, Your Excellencies, in the case of African Commission versus Kenya. Allow me to cite a scholarly thesis persuasively to you. I cite a thesis by Dr. Nancy Baraza, who was the former Deputy Chief Justice in the Republic of Kenya. Her thesis is titled, The Impact of Heteronormativity on the Rights of Sexual Minorities. In her thesis, Your Excellencies, she notes that indeed the provisions of the African Charter do not provide for sexual orientation as a ground for discrimination. However, Your Excellencies, she notes that the usage of the words other grounds opens up the provisions of Article 2 of the African Charter to interrogation or rather for inclusion of other grounds for discrimination.
But the agent, you are very much aware that the African human rights system is a very unique one to the African setting. And if you look at the preamble and all that, the cultural and traditions of Africa, a very important background. So on what basis do you want to invite this court to recognize sexual orientation as a maintainable ground for discrimination?
Much obliged to Excellencies. I cite the decision of the African Commission in Zimbabwe NGO Human Rights Forum versus Zimbabwe at paragraph 169, where the Commission allow me to proceed, Your Excellencies. I cite the decision of Zimbabwe NGO Human Rights Forum versus Zimbabwe at paragraph 169, where the Commission did in fact recognize sexual orientation as a ground for discrimination. The Commission went ahead and stated that, in fact, sexual orientation provides for equal treatment of persons despite their sexual orientation. Your Excellencies, that is the authority that we rely on. Again, Your Excellencies, allow me to cite Resolution 275 by the African Commission that was released in 2014, where indeed sexual orientation was distinguished or was recognized as a ground for discrimination. Much obliged to Excellencies. In regards to our second limb of argument, we submit that the limitation pursued by the State Republic of St. Sphere did not meet the 4-pronged test that was set by this court in the case of Issa Konate vs. Burkina Faso and Victoria Ingabire vs. the Republic of Rwanda. We admit, Your Excellencies, that in fact rights are not absolute and they can be limited. But again, Your Excellencies, for For these rights to be limited, it ought to be provided for by law, it ought to be necessary, it ought to be proportionate, and it ought to be justifiable. We submit, Your Excellencies, that the State Republic of St. Sophia did not meet any of these tests. Allow me to begin by the requirement that the objectives of Center for Sexual Minority Rights were indeed in conformity with the law. We cite the decision of the African Commission in Malawi African Association and others was the Republic of Mauritania, where the Commission was of the opinion that any law on association ought to include an objective description of its objectives in order to determine its criminal objectives.
By agent, it is clear from the fact that the respondent state has the Unnatural Offences Act, and clearly what Center for Sexual Minority sought to do was to promote activities which are contrary to that legislation. So can this court actually entertain the argument that you are making now?
Much obliged, Your Excellencies. I shall answer your question in two arguments. Firstly, allow me to cite a decision of this court in Ajavon versus Benin, a 2020 decision, under paragraph 122, where you held, Your Excellencies, that any limitation on the rights, on any right, the meaning of the words ought to be provided by law means that any limitation ought to be consistent with international set standards. Your Excellencies, we submit that the State Republic of St. Sophia, in the continued enforcement of the Unnatural Offences Act, does in fact violate the right of sexual minorities in St. Sophia as provided for under the provisions of Article 10 of the African Charter. In alternative, Your Excellencies, we note that we implore to this court that indeed there is a difference between the activities of sexual minorities and in fact what they sought to promote, or rather what Center for Sexual Minority Rights. Your Excellencies, I shall be demonstrating this in my next limb of argument. But in order to answer your questions, Your Excellencies, we note that St. Sophia is steeped in ancient tradition and culture. If indeed the respondent states were committed to promoting the rights of sexual minorities, then they can go ahead and enforce the Unnatural Offences Act, as the activities of Aisha under the provisions of paragraph 26 were only to promote the rights of sexual minorities. To be specific, the right to health, the right from homophobia, the right to lesophobia. And in fact, Your Excellencies, if they seek to indulge with what LGBT persons do in private, they can continue and enforce the Natural Offences Act.
Agent, can you show from the facts one instance where LGBTI person was denied access to health or any other right, for which reason this court should entertain the present argument you are making?
Much obliged, Your Excellencies. From the fact sheet, we are not told of any specific instance where these persons were denied their right to health. But again, Your Excellencies, allow me to note Resolution 275, where one of the recommendations from the Commission was that respondent state should refrain from interfering with the rights of these persons, including verbal attacks on these people. But again, Your Excellencies, under the imports of paragraph 25, we see a minister by the name Kwame verbally attacking LGBTQ persons, Your Excellencies. We see the actions, or rather the words of the parents in St. Sophia who go ahead and term her as an agent of the dark. Your Excellencies, this we submit is a first step towards the limitation of rights of sexual minorities. Much.
Vous plaidez avec conviction et passion pour la non-discrimination à l'égard des personnes homosexuelles, notamment. Est-ce que pour légitimer et renforcer votre argumentation, vous pourriez présenter à notre cours des jurisprudences venant d'Europe ou d'Amérique latine qui conforteraient votre argumentation sur la nécessité de ne pas discriminer les personnes homosexuelles?
My lady, if I may beg your indulgence, I didn't hear your question. I didn't have a translation.
Those in charge of the translating gadgets, I think the volume went down. So
I will try in English. I'm able to do it in English.
Right. So can you do it in English?
Yes.
All
Yes. So you present with passion the need to not discriminate homosexual persons. But can you rely on an important trend at the European level or at the Latin American level, case law from the European Court or the Inter-American Court in order to legitimate more your argumentation?
Much obliged, my lady. Allow me to cite a decision from the European Court, but unfortunately, Council only remembers facts but cannot remember the law. But again, the European Court of Human and People's Rights was of the opinion in a certain case, I can't remember the actual citation, that the limitations sought by the Republic of Russia for limiting 3 LGBTQ persons from registering their organization was in fact discriminatory and a violation of the right to freedom of association. Council stands guided on the citation of the case, but Council knows the facts of the case and the holding of the European Court. Much obliged, my lady. In regards to reasonableness and necessity, we cite that the actions of the State Republic of St. Sphere were unreasonable and unnecessary. We note the imports of paragraph 27 of Article 27.2 of the African Charter, which provides that rights ought to be exercised with due regard to the rights of others, common interest, and morality. Your Excellencies, we submit that firstly, morality cannot be used as a ground for limitation of this right. Your Excellencies, it's impossible for the respondent state to cite morality as an actual ground for limitation of the rights of fundamental rights of LGBTQ persons in St. Sphere.
Agent, I want to ask a direct question. Is there a right to sexual orientation or sexual preference within the African system?
Much obliged, Your Excellency. Indeed, the African Charter does not recognize any special right for LGBT persons. But again, Your Excellencies, the wordings of Article 10 of the African Charter is that all persons have the right to freedom of association. Your Excellencies, it's all persons, regardless of their sexual orientation. And as such, Your Excellencies, we submit that sexual minorities or other LGBT persons have equal rights to all other persons, not only in St. Sphere, but also in Africa. Again, Your Excellencies.
One of topics of admissibility is that the request must be according to the African Charter and African rules. Some African countries argue that LGBT and this kind of topics are against the nature of African traditional beliefs. What is your opinion about this? Thank you.
Much obliged, Your Excellency. We note from statistics that at least 33 countries in Africa have criminalized LGBTQ rights. But again, Your Excellencies, at least 99% of African countries have gone ahead and ratified and adopted the African Charter. We submit that in as much as these countries have criminalized LGBTQ rights, Your Excellencies, these countries still tend to respect LGBTQ rights in Africa, Your Excellencies. But again, Your Excellencies, kindly pardon me on your question. I've forgotten my train of thoughts.
The question is an invitation for you to express your opinion as to whether the right of LGBTIs or the right to choose your sexual orientation, which is not explicit in the African Charter, whether that should be recognized, having regard to African tradition and African culture.
Much obliged, Your Excellencies. In response to your question, allow me to cite the ICCPR General Comment number 21 under paragraph 12 and paragraph 13, where they cite that culture is a way of life. But again, Your Excellencies, the committee notes that culture can in fact be practiced by a group of persons or by a community, Your Excellencies. In as much as African culture, or rather, in as much as African states might cite culture as indeed a limitation of these rights, we note that firstly, culture is not static. Culture can change, Your Excellencies. And as such, if people intend to practice these rights as a small group, they ought to be accorded these rights. But again, Your Excellencies, guided by the fact sheet, Your Excellencies, Aisha has been existing in St. Sphere. Your Excellencies, she formally identified herself as Felix Caesar, Your Excellencies. Your Excellencies, under paragraph 25, the State Republic of St. Sphere knew quite well that Aisha exists. Your Excellencies, we note that her tweet was in 2021, but the respondent state first curtailed her rights in 2022. And as such, Your Excellencies, these people exist within our community. We recognize them, Your Excellencies. And that's why, Your Excellencies, we approach this court for the enforcement of these persons' rights, Your Excellencies. Much obliged, Your Excellencies. In regards to necessity, we cite that, first of all, common interests, and I rely on the case of constitutional rights projects and others versus Nigeria, where the Commission noted that the African Charter does not contain any derogation clause. Your Excellencies, as I've earlier alluded, the respondent state knew of the existence of Aisha. Your Excellencies, under paragraph 24, her tweet was made on 16th July 2021. Under paragraph 25, Your Excellencies, Aisha has been advertising in the local televisions in St. Sphere. We submit, Your Excellencies, that citing common interest, collective security as a ground for limitation of this right cannot be justified. The people who are visiting Aisha's center were aged around 20 years, Your Excellencies. These are adults, Your Excellencies. These are people who have the right to freedom of choice, Your Excellencies. We submit, Your Excellencies, that the limitation pursued by the government of the Republic of St. Sphere was unnecessary. In regards to proportionality, Your Excellencies, we note the provisions of Article 10, which provides that rights ought to be exercised in accordance with the provisions of Article 29, which provides for the right to culture. In the case of constitutional projects and others versus Nigeria, it was noted that limitation of rights ought to be directly proportional to the intended purpose. Proportionality is concerned with the less restrictive measure that ought to have been accorded by the government. We note the case by the African court in APDF and IHDR versus Mali, where the respondent state was relying on insufficiency, or rather on its traditional values, as a ground to promote retrogressive cultural values. But again, Your Excellencies, you held that the respondent state ought to make sure that its national legislation are in accordance with the international obligations, Your Excellencies.
Agent, if this court were to make a favorable ruling on this particular claim, will you be inviting the court to hold all African states that do not recognize the rights of LGBT persons to be in violation of the African Charter, a relevant human rights instrument?
Much obliged, Your Excellencies. We submit that each case ought to be determined based on its own peculiar circumstances. We will not be inviting this court. What we are arguing about is the right to freedom of association of these persons that has been guaranteed under Article 10 of the African Charter, and these persons ought not to be discriminated against. We are not asking you to rule that respondent states who have gone ahead and criminalized these activities should actually decriminalize them. But we argue that these persons, just like any other persons, have the right to associate and form organizations. Seeing that my time is far much spent, Your Excellencies, I seek 1 minute to submit on the last issue, or rather on the last sublimb of our argument.
Go ahead.
Much obliged, Your Excellencies. In regards to our last argument, we submit that the actions of the respondent state was indeed a violation of the right to freedom of association. We cite the decision from the African Commission in the case of law offices of Suleiman Ghazi, where the Commission found that the actions of the respondent state of preventing Mr. Ghazi from interacting with other members of the society and discussing human rights matters and going ahead to punishing him was in fact a violation of the right to freedom of association. Having established, Your Excellencies, but the actions of the Republic of St. Sphere was discriminatory, was not provided for by law, was unproportionate, and was unnecessary, we submit that restricting this right was indeed a direct infringement of the right to freedom of association. We also urge you to be guided by the decision of the African Commission in the case of Civil Liberties Organization versus Nigeria, under paragraph 14, where the Commission noted that the right to freedom of association includes an obligation not to interfere with the rights of persons, Your Excellencies.
Agent, your time is up.
Much obliged, Your Excellencies. Seeing that my time is far much up, Your Excellencies, the applicants wish to rest their case.